Hello, everyone. Thank you for joining us for the second session at Women of the Forefront of Insolvency Symposium. My name is Karen Fellows. I am speaking to you from Canada. I am a lawyer with Stikeman Elliott in law firm in Canada, and I am the IWIRC Finance Director. On behalf of IWIRC and III, I'd like to welcome everyone to this session. The session is entitled, "What Color is Your Rescue Financing Parachute? Examining the Hues in Southeast Asia." And we've assembled an excellent panel moderated by Pooja Sinha, and I'm very much looking forward to hearing about this topic. A few housekeeping issues. I can advise that with respect to the symposium itself, attendees can attend any of the sessions if they'd like to register for other sessions, even if they did not pre-register for them. Please go to the symposium website and look at the other sessions that are upcoming. And if any of our interest to you and are available, you are free to register for those. I can tell you that the materials and the bios for the speakers can also be found on the symposium website. And CLE or CPE code and credit will be posted in the chat function during the course of this presentation. So please look for that in the chat function. And you have to have that code when you're applying for the CLE or CPE credits in your jurisdiction. I can also tell you that the code will be sent to all attendees after the session, along with a brief survey. Please note that all sessions are being recorded and will be posted on the IWIRC YouTube channel for the next 2 weeks. So you'll have an opportunity to review them in the recorded format. And we do encourage questions, pending time restraints, of course. So please use the chat function, which is located on, I believe, the upper right corner of your screen, to post your questions in the chat feature. And our moderator will view those questions, and if there is time available at the end of the presentation, during the presentation, at her discretion, will endeavor to answer those questions. So please post your questions. We look forward to hearing from you. With that being said, I'm going to pass it over to our moderator, Pooja Sinha. Thanks, Pooja.
Thank you, Karen. So let's talk this morning about rescue financing. Now, when you say rescue financing in a Western context, particularly a US context, it has a very defined meaning. It's about the Chapter 11 process. It's about rescuing a business as a going concern with a view to keeping it alive or selling it going forward. As you know, the Chapter 11 process has several legal tools built in to make it easy for lenders to provide rescue financing, including through super priority financing. Now, in a Southeast Asian context, what do we mean by rescue financing? Quite honestly, it depends on who you ask and where they're located. It pretty much guarantees an eye roll from no matter who you ask. And that's because there's a host of factors that work somewhat differently in Asia. There's cultural factors, there's institutional factors, such as different kinds of creditors, etc., different kinds of perspectives in the mix from creditors as well. And then there's, of course, the legal factors as well, in terms of the efficacy of legal tools available to bring about a successful R&I process. So going back to the panel title, what color is your parachute? If you look at some of the stereotypes that prevail, if you asked an average Asian debtor, he would tell you strenuously that he does not have any need for a parachute whatsoever. If you ask the creditor community, be it an existing lender or a rescue financier, you would find that this is not one of those situations where you can order a parachute off the shelf. It'll come nicely and neatly packaged in a delivery box to your doorstep. It's very much about customized solutions. It's about finding bespoke solutions that fit the debtor profile, the creditor profile, and indeed the jurisdiction in which the debtor operates as well. So with that, let's set some context in terms of what are we going to cover on this panel. We have a large audience, both based in Asia and the US, and we intend to have takeaways for everyone. For those that are uninitiated, we hope to provide a bit of an overview of some of the challenges that are involved in a Southeast Asian context where rescue financing is concerned. For the experienced R&I practitioners on this call based in Asia, we're also going to share some very practical solutions that have been found to bring about rescue financing. For this, we're going to draw upon the experience of an all-star panel that has been at the coalface of rescue financing deals. The diverse perspectives that we bring on this panel include a banker, a special sits fund, a restructuring deal lawyer and litigator based in India, one based in Singapore, and an international deal lawyer as well. So with that, let me move to a little bit of background on the panelists, a specific background on the panelists. They all have very stellar CVs, as you have seen from the panel invite already, but just to provide some context on their experience. We have here Angelina Bopp, who is the head of restructuring APAC at MUFG. She's based in Singapore. She's a qualified solicitor with 20 years experience in corporate, commercial, PE, and investment banking structures. She's an R&I expert who has done turnaround and recovery deals across the Asia Pacific. We have Mayuri Gupta, an executive director with Heirs SSG based in Mumbai, India. She focuses on private credit, distressed investment, and special sits in India. She has a decade-long investing experience across multiple strategies in PE, turnaround, private credit, and special sits. We have Mei Yen Tan, who's the head of the R&I practice at Oon Bazul, a Singapore law firm. She works on consensual and non-consensual restructuring, cross-border disputes, corporate fraud, and investigations. We then have Pooja Mahajan, who is a managing partner of Chandhiok and Mahajan, a law firm based in New Delhi, India. She advises clients on a number of transactions involving doing deals across the spectrum in India, M&A, financial restructuring, and general fundraising as well. As for myself, I'm an associate director at Forte Law LLC, a Singapore law practice based in Singapore. I have worked on a number of transaction restructurings in Hong Kong, India, and Indonesia, representing debtors, creditors, bond trustees, and special sits fund. So with that, let me just dive in. We will first start with setting the stage in terms of what are some of the challenges in terms of doing rescue financing deals in Southeast Asia that I alluded to earlier. Now, I'll outline some of the common stereotypes that we all come across. There's the cultural stereotype. There's generally speaking, a trust deficit between lenders and debtors. Number of businesses in Asia are family owned, continue to be privately held. Governance structures are opaque. Capital raising structures also tend to be quite opaque. There's also institutional factors that we see at play. As I mentioned earlier, diverse creditor groups with their different commercial drivers, and a general decision apathy, as it's called. There are also legal factors. Again, R&I regime in a number of Southeast Asian countries is quite new. They're generally less well developed as compared to the Western counterparts. And in emerging markets, there's also the additional issue of local restrictions that apply to foreign lenders and creditors, including rescue financiers, as opposed to domestic players. So let's kind of take that in turn. Let's start first with addressing the cultural and institutional factors for the benefit of our international audience in particular. And for that, I'd like to call upon the non-lawyers on the panel to begin with to share their commercial perspectives. So in terms of the stereotypes that I've just outlined, the cultural and institutional stereotypes, in your experience, are these stereotypes true? Do they hold true in the context of deals that you've done? And also, I'd like you to address the sort of elephant in the room question. How has the post-COVID landscape affected behavior of various market participants in terms of, where do you see the stress and the distress market today, and how has it affected behavior? So if I could call upon Angelina first.
Thanks, Pooja. So there's actually two reasonably distinct questions there that I think you have posed. The first one is around, are the cultural stereotypes that you've just outlined true? And, the whole thing about stereotypes clearly is that they are stereotypes, and so they don't necessarily apply in every context. If we're applying the 80-20 rule, I would say that in many cases they do apply, but not necessarily out of bad faith. So I think there is a very general propensity towards not necessarily engaging sufficiently early with advisors or with lenders as, for example, a large conglomerate or a family-owned business. Because generally speaking, the default is to try to deal with the issues internally rather than necessarily recognize the size or scale of the issue. And I'm deliberately not using the word problem there, because it is an issue that needs to be overcome rather than necessarily a problem that is manifesting. And I think the consequence of that behavior is that often by the time the issue has manifested into a problem, it's actually too late for many of both the practitioners and also the advisors and lenders and creditors to the company to take meaningful action that will allow that company to often trade out of difficulties, because that is the holy grail for restructuring, right? It is actually to address either the operational issues or alternatively the capital structure to achieve a better business over the longer term that is capable of servicing its debt. So I think that's one of the real challenges of operating in Asia. And then there is also, you know, some of the other things that you have outlined around this divergence of interests, both amongst the creditor group and also at the company, which is no different to any restructuring anywhere else, you know, anywhere else in the world. Those issues always exist. What is exacerbated, I think, in Asia actually is the relative lack of trust between each of the counterparties. And I think that is magnified even further by some of the kind of legal and regulatory challenges that you outlined at the beginning. Because in the absence of good disclosure, which many of the jurisdictions that we operate in here do not have, because there is much more secrecy, I guess, around you know, what needs to be disclosed in the capital structure and the corporate governance of a particular business. All of these things make it make the level playing field much more challenging. So that was a long answer to your question around the cultural stereotypes apply. I would say yes. In terms of coming on to the second part of your question about the post-COVID landscape, I think honestly right now it's too early to tell. In the majority of the countries across Asia have had sort of government or regulatory moratoria applied to those corporates. And so there has been a huge amount of support and a huge amount of liquidity that still exists in the market. And so I think it's a bit too early to tell whether or not the COVID landscape is going to change borrower behavior. I think what we are starting to see already, and I would say this applies across the globe, is a sort of K-shaped recovery. So, you know, there are certain businesses and there are certain industries and certain sectors that are weathering the storm better, but there are also corporates within those same sectors that are weathering that storm very, very differently. And there's a number of different factors for that. So I'll stop there and hand back over to you, Pooja.
Okay, thanks, Angelina. That's very useful. I think interestingly, it's a little bit of a similar trend even in the US market, where the R&I market is sort of moving in unexpected ways, right? There's just been, you know, less R&I than market practitioners had expected. So with that, Mayuri, if I could ask you to comment on what you're seeing in an Indian context. I think several similar themes, I would suspect, relative to what Angelina said as well, but it'd be great to hear from you specifically on India as well.
Sure. You know, see, themes are similar, but it's important to look at this whole insolvency regime in India really understand, fundamentally where it stands. So if you see, the insolvency code in India has been nothing short of seminal in nature. The unique and fundamental aspect of the insolvency regime in India is that it's a creditor in possession regime, with the central idea being the commercial wisdom of the Committee of Creditors, which replaces the Board of Corporate Debtor after initiation of insolvency to manage the entity as a going concern through the appointment of a resolution professional. Now, across the several restructuring or debt resolution schemes prevalent until now, IBC is literally the only instance of legislation which has triggered sustainable behavioral change. And it's very important to understand that it's a behavioral change, number one, and number two, it's sustainable. This has, and we actually witnessed this on part of both the lenders as well as the promoters, the debtor, because the lenders now want to lead the resolution actively, because this as well as they feel much more in control of the situation versus what it had been until now. Whereas on the borrower side, we note that they realize finally that there is absolutely no leeway in getting away with defaults and non-payments to the banking system. So in that context, and this sustainable behavioral change that I talked about very much holds true in the context of both a pre-COVID and post-COVID. While it is still early days to really say how the R&I landscape is going to change post-COVID, because like Angelina just said, there's been moratorium from the government, but nonetheless, this specific aspect holds true regardless of the time that we are talking about. As the regime further evolves, there are going to be further context-specific optionalities which are being formulated. The most important one that we could, talk about at this time is the concept of a pre-packed deal upon early signs of stress. And that is exactly, Pooja, which is going to be seminal in terms of breaking down the stereotypes that you mentioned. Because, and that's also going to be a demarcation from a creditor in possession to a debtor in possession for the implementation of a rescue plan. So I would say that much work done and some more in the works.
Okay. Thanks, Mary. That's very helpful. I think India is a fascinating example of the government bringing in a law to bring about this mindset shift, and that's actually happened in practice as well. So I think that's very interesting indeed. So I think with that overview of cultural and institutional factors, let's now dive into the legal factors. I think again that's very important in the Asian context as well, and Angelina touched upon that as well. So for the benefit of an international, for the non-Asia audience, I think let's just give a very high-level overview of what the local R&I regime is in our focus countries, Singapore, India, Indonesia. So I'll start very briefly with Indonesia. So if you do want the benefit of a court-approved restructuring process in Indonesia with a moratorium, etc., then you have to go under what is known as the PKPU. This is a debtor in possession regime, and effectively it gives all participants a time-bound process in which they have to reach a consensual restructuring. This is called a composition plan. And if you don't reach that consensus, then under the law, a bankruptcy of the company automatically gets triggered. So it kind of builds in this little pressure cooker to get the deal done in that short period of time. Now, as practitioners in Asia know, the PKPU process has several challenges. I think it's perceived generally to be debtor friendly. Local debtors have the home ground advantage. And also more critically for international financial creditors in particular, there's been a lot of challenges around the fact that Indonesia is a civil law country. So in a number of cases, local courts, local administrators have applied civil law concepts to international finance documents, meaning that standard concepts such as trust arrangements, use of SPVs to raise capital, etc., have actually not been recognized in a restructuring process. So those are the challenges that one has had to contend with in an Indonesian context. So with that, let me hand over to Mei Yen for a brief overview of the Singapore process.
Pooja, I'm so sorry. May I just jump in at that point just to add a comment on Indonesia, which I think for practitioners is really worth noting. The first thing is around the importance of the first mover advantage in Indonesia, because ultimately it is the administrator of the composition plan that controls the process and makes the decisions around, you know, whether claims are admitted or not. So that's a really key point. And I guess the other one is just around, and it relates to this civil law point that you were talking about, which is just that there is no real certainty about what the outcome will be in Indonesia. And that presents a real challenge for creditors because, you know, wanting to use the PKPU process, because you may think you're after one particular outcome, but actually you may have a local judge in, you know, one of the smaller provinces making a ruling that then subsequently needs to be appealed or reversed, and that just creates quite a lot of confusion in the market.
Absolutely, and I think this is a little bit of a common theme in India and Indonesia. I think India perhaps to a lesser extent now that the law is more settled, which is this uncertainty risk which ultimately gets, you know, priced into deals. So I think that's actually a perfect segue into Singapore and the purported certainty that the regime offers. Over to you, Mei Yen.
Hello and good morning from Singapore. Well, first, let me give you an overview of the Singapore regime before I move to the next question, that the regime is perceived as undeveloped. Rescue financing in Singapore was introduced in 2017. An application can be made for rescue financing in two situations. First, where the company files for leave to convene scheme meetings. And secondly, when the company files for moratorium with the intention to propose a scheme. Rescue financing in Singapore is defined as any financing that satisfies either or both of the following conditions. First, the financing is necessary, and second, it's necessary for the survival of the company or a whole or any part of the undertaking of that company as a going concern. And secondly, the financing is necessary to achieve a more advantageous realization of the assets than in a winding up. In terms of the levels of priority that the court can grant to the rescue financing, these are as costs or expenses of the winding up, in priority over all preferential debts and other unsecured debts. This will of course rank above liquidators' fees and expenses. It can also grant a security by way of a security interest, not otherwise subject to any other existing security or subordinated to an existing security interest. And finally, and obviously this is what will be perceived as the most draconian relief that can be obtained, you can get your financing secured by security interest of the same or higher priority than an existing security interest. This is usually known as a priming lien. In respect of all of the levels of priorities that I've mentioned, save for the first one, the company will have to show that it would not have been granted, it would not have been able to obtain such financing without it being granted such priority. And finally, for the last one, the priming lien, you also have to show adequate protection for the existing secured creditor. I now move on to the stereotypical view as to whether the regime is underdeveloped and whether this is the correct view to take. In my view, the Singapore's legislative changes, which amongst other things have introduced super priority financing, puts it as a leader in Asia in distress financing. Debtor companies, whether local or foreign, if they can show substantial connection to Singapore, can now come to Singapore to take advantage of the rescue financing regime here. The courts here have also granted orders for super priority financing in appropriate cases and have clearly indicated that it will look to the US authorities in developing Singapore's jurisprudence. In light of the above, it will be difficult to say that Singapore's regime for rescue financing is undeveloped, especially when compared to other countries in Asia. Having said that though, there is a perception that there is still some uncertainty in the Singapore regime, This is due to the novelty of the regime and hence very few reported cases providing guidance. I think this is to be expected, and I'm confident with the passage of time, this uncertainty will be addressed. The other point I wanted to make is that users of the regime, in particular debtor companies, need to also make a mindset shift. They need to be more candid and open about their distressed situation and gain the trust of their creditors in order to achieve a cooperation to effect a successful restructuring. I think given these sort of things, if there is a change in the behaviors of the users of the regime, this will move Singapore to a better position as a hub for debt financing. Thank you, Pooja. I'll give this back to you.
Thanks, Mei Yen. That's very useful, I think, just in terms of the overview of the regime and tackling the stereotypes about Singapore itself, and also some how to sort of overcome some of the challenges. I think again, just while we sort of have you speaking, obviously there've been some success stories in Singapore. You've been front and center of a number of those deals. So I think it'd be great to kind of really dive into the meat of this panel, which is that what are some of the practical challenges you faced in getting your deals across the line, and what are the takeaways from that for other debtors? I think you alluded to some of those already, but I think maybe if you could just elaborate a little bit on the cases that you were involved in and some of the specific challenges that you had to overcome.
Of course, Pooja. What I'll do is I will touch very briefly on the various cases that have come to the Singapore courts and have been successful in terms of obtaining their orders for super priority financing. The first case to obtain a successful order in terms of super priority rescue financing was asiatravel.com. This was a case in which we acted for the debtor company, and we successfully showed that existing lenders and other third-party financiers were unwilling to provide financing without super priority. And once we showed that, the court then gave the order for the super priority financing. Then sometime in 2020, there was a case of Design Studio Group. This is a reported case. The court in this case had to consider the issue of rescue financing and roll-ups. For the audience who may not be familiar with a roll-up entails applying all or a portion of the rescue financing proceeds towards paying off pre-existing debt owed to the rescue lender, thereby upgrading the pre-existing debt into a super priority debt. The court observed that roll-ups not only raised the priority of the pre-petition loan, but they raised it to the highest possible level, i.e. they were paid in full. The court also observed that although the proposed financing was a roll-up, this did not affect the finding that it constituted legitimate rescue financing. There was no statutory prohibitions against roll-ups, and therefore roll-ups constitute rescue financing as long as they met the requirements, which are necessity and the non-availability of non-super priority financing. The third case I wanted to touch on is an unreported case of Srihong Limited. This case raised an interesting issue, that is whether the court can grant super priority status to financiers where part of the financing of approximately 2.9 million was disbursed to the company prior to any super priority order being made by the court. It was found that this was permitted under the language of Section 211EB, but not Section 211EC, and consequently Section 211ED. So it's interesting, if you look at these subsections, subsection B covers financing and it says obtained or to be obtained, whereas subsection C and D only applies to financing to be obtained. So in this case, what the court did was it granted super priority for the pre-petition debt at subsection B, but did not provide it under subsection C. And this is the difference in this is likely because subsection C and D accords a higher priority than subsection B by granting actual security interest to the DIP lender. With that, these are the three cases so far that Singapore has encountered. So back to you, Pooja.
Right. Thanks, Mei. So I think, just kind of drawing some themes from what you said, it looks like what you really need to do to effect a successful rescue financing through Singapore courts, among other things, is firstly, there's still a little bit of jurisprudence, so to speak, to be settled around, the new law, what section you can sort of go under, what is the scope of those sections. Courts seem to insist on there being, some sort of due process built in, right? So, they'll grant you the order, but they'll kind of want you to do the background work to make sure that that's really the best option for the company, and kind of have that on record, so to speak. And then finally, they seem to be kind of not shy to draw parallels from what's happened in equivalent situations in the US. Would you agree? Anything else that's
yes,
kind of practical that I've missed out?
No, I think you've hit it spot on the nail. In Singapore, I think one of the things that was very clear to me when advising my clients is that I do really need to show the court that you have made an effort to go out there to look for financing that does not require super priority, and you need to show that evidence to the court. If you didn't bother doing that and immediately made an application to have a financier come in with a super priority status, the court will not grant your order. Also, I mean, some of the challenges we face, which I think will be resolved in due course, obviously, all this takes time, is basically, for example,
sorry, Mei, can I just come back to you on the challenges? I think we'll just deal with that a little bit later.
Yep.
And I've already had some questions on that as well, actually, for you. So I'll collate all that. So I think just shifting gears to India. Pooja, Mahajan, if I could kind of call upon you, I think Mayuri already gave a little bit of an overview on the process in India, but maybe if you could sort of, elaborate on how really it's been sort of in the trenches. You've been actually arguing before the tribunals in India. How have you sort of seen the law evolve, and what's the sort of takeaway from that for international players in particular who are sitting outside India and not really being able to sort of sometimes discern trends and takeaways from all the action that's going on?
Thanks, Pooja. Very good morning to everyone. Pleasure to be here. So, as Mayuri very rightly mentioned, IBC for us, Insolvency and Bankruptcy Code 2016, has been a game changer as far as India is concerned. So I will draw a line in the sand and talk about things which are within the scope of Insolvency and Bankruptcy Code and things which are outside the scope of IBC. When we talk about IBC itself, it is a formal restructuring process driven by national company law tribunals, which are NCLTs, the bankruptcy tribunals in India. It's a creditor in control, creditor in possession model, which is actually designed in a manner where control is taken away from the promoters and vested in a resolution professional. And even the resolution process is more suited to what I would say a merger, an M&A process, as opposed to getting the promoters back to rescue the company. We have Section 29A, very famous and very well debated section, which actually disqualifies certain categories of bidders, including a lot of promoters from bidding for their own company, which has actually led to control of these companies being shifted to a third party by way of an insolvency process. A big game changer. As far as the difficulties of the process itself are concerned, the law is evolving. And I think we've had good success in the last 3 years in terms of settling a lot of jurisprudential issues. The big concern, as far as, from a practitioner's perspective that I see, is around the court process. So while the commercial wisdom of the Committee of Creditors prevails, and while everyone understands that it's the Committee of Creditors who are finally deciding how to rescue a company and how to restructure the company, there is a heavy involvement of the NCLTs in many cases. And the process itself sometimes becomes very downtrodden. There are multiple litigations, especially from promoters, who do try to find all ways to get the company back. And that has led to a lot of prolonged litigation in many of these cases, We have concerns around, the capacity and the infrastructure of the bankruptcy tribunals itself in dealing with the number of cases that they deal with. And that itself creates a lot of uncertainty, and a lot of time really goes by, and which really leads to deterioration of the assets and the value of the assets in the process. That's as far as the within IBC regime is concerned. When we talk about, and sorry, just before I move on to outside IBC process, from a rescue finance perspective, there are provisions in the Insolvency and Bankruptcy Code for interim finance, and there is priority which is given to interim finance. The difficulty, of course, is that we have not seen many cases of interim finance within the IBC, and there are various challenges and reasons for it, which we can, come to later. As far as outside IBC process is concerned, we do have schemes of arrangement under Section 230 of the Companies Act. Unfortunately, they are very, very rarely used for debt restructuring. And one of the primary reasons is there's a lack of moratorium, and there is no cross-class crampdown. So those are two big reasons why we don't see schemes of restructuring being used in the Indian context. Other than schemes of restructuring, most of the restructurings in India outside IBC take place under various circulars issued by Reserve Bank of India, which is the central bank. And these are essentially circulars issued by RBI to banks and non-banking finance company around prudential regulation. And these circulars really enable restructuring process, which could also be, you can say a debtor in possession restructuring is possible under these circulars. The difficulty here, of course, is understanding what is the priority which a rescue finance will get in case a rescue finance is given in pre-IBC, because as of now, there is no priority accorded to any kind of financing which is given in an outside IBC process. And I think that's a big deterrent as far as rescue financing is concerned. So that's just the broad overview of the legal regime in India.
Right. Okay, thank you. And I think we'll come back to some of the specific challenges, particularly that overseas financiers face, a bit later on in the panel as well. I'd like to hand over to Mayuri now. So I think what Pooja Mahajan explained, the code has evolved a lot, but there's still some challenges, still a multitude of forums that one can use. So how have you seen rescue financing deals being done in practice, Mayuri? What are some of the workarounds that you've seen?
So let me talk about an investor's perspective here. So just touching upon the basic concept of rescue financing, that it is pre-distressed and that there is scope to shore up the equity value in a business. The challenge that we typically face as investors in consummating rescue financing transactions they can broadly be categorized into two buckets. The first being structural issues, such as security package. Existing lenders do not necessarily allow seniority despite the pre-stress situation of the company, and reasons could vary, across peculiar to circumstances. But overall, we have seen there is typically a difficulty in agreeing upon a security package. Secondly, operational issues such as creation of charge in the very rare circumstances where there is agreement on seniority of the security package, just because of the whole requirement of the process of getting NOCs from existing lenders, the vast number of existing lenders, etc. It just gets delayed inordinately, because of which ultimately you are not able to consummate rescue financing in the classic sense. However, that doesn't mean that rescue financing is not happening. We are looking at a modified version of rescue financing, which is currently in practice. And what is typically done here is that, let's say you have a corporate group. You pick a performing asset within that group and you loan against that performing credit, with the clear understanding that your financing is going to be used for the rescue of the non-performing asset within that group. Naturally, while this works well and there are success stories of this specific workaround, naturally the constraint with this workaround is that not every situation has an alternative working asset performing credit. So what do you do in those situations? That is what brings you back to the square one of not being able to then apply a rescue financing package. And if I could also touch upon one more thing, which is quite critical, especially in the Indian context, is what sort of post-lending controls we institute as investors, even in case of rescue financing deals. So we go through our typical cash flow control mechanism. There is a trust and retention account to secure the cash flows, which are basically, because rescue financing is always done based on the fundamental underwriting is going to be on the cash flows of the company, number one, followed by a second layer of protection, which is collateral of the security package, which is on which you have seniority. So to control that, typically we use a TRA and other cash flow monitoring procedures.
Okay, thanks, Mayuri. I think that's very interesting. So, even in this kind of complex regulatory landscape in India with, so many different factors to keep in mind, it is possible to do deals. One just has to sort of structure them differently. So I think just, in a similar theme, just very briefly, I think in Indonesia, it's somewhat of a similar situation in my experience. I think generally you have better outcomes if you do deals outside of the formal process. Again, as Angelina highlighted earlier, there's just too much uncertainty in the formal process. And so the deals that I've seen are kind of bilateral special sits financings done in kind of pre-default or immediately after default context, and those are generally outside the PPPU. So if I could now just call upon Angelina, I think, have you seen anything different in Indonesia? And now you sort of heard, the developed Singapore market perspective, the emerging market India perspective. I mean, what's your sort of general take on, these regimes, and what would your advice be for a debtor seeking to do a rescue financing in Asia?
Thanks, Pooja. I think the thing that's really interesting about working as a practitioner in restructuring in Asia is that all of the markets are so different. And actually, it's really, really difficult to generalize across all of the markets, because I think, as you had said at the outset, there are very significant cultural differences between each of the countries, and then all of the regimes are slightly different. If I were to think about, and that's what makes it so exciting, right? That's what makes it so interesting, that Mayuri can think about the existing regime, but also think about actually what are the workarounds to achieve the outcomes that we want to achieve. So it requires a really high level of creativity, I think, in terms of problem solving and structuring. So I think one of the key themes that can be applied across all of the jurisdictions, and in particular in the context of advice to a borrower, it is actually, rather than trying to fix the problem yourself, engage early. Now, that doesn't necessarily mean engage with your lenders, although clearly from a lender perspective, that would be my preference. But regardless of that, engage with your advisors early, engage with your legal advisors, obtain professional help, because in doing that, you may well find that you're able to find or implement a workaround solution, to use Mayuri's example, a workaround solution that enables your business to be saved in a more sustainable fashion than if you leave it for too long. So that's one of my really big ones. And the kind of converse of that is for creditors to make sure that you are identifying those early warning signals early enough and engaging with your borrowers at a sufficiently early stage of the process so that you can try and work out a solution together. And I don't think it's any coincidence, Pooja, that where you're talking about solutions, particularly in the Indonesian context, these are bilateral solutions that have been found, because there's only two parties that right. You're kind of negotiating with, and I think that makes a really big difference. So limiting down the number of stakeholders that are involved in a particular transaction, whilst not always possible, is often desirable.
Yep. Yeah. Thanks. All of that I think resonates. I think with what I've seen as well. So I think let's then sort of pivot to some of the specific challenges that international distressed debt investors face, right, when looking at the Asian landscape. So I think let me start with Singapore and then going back to Mei Yen. I think one of the questions that international funds often ask is, what can I do or what can't I do in Singapore that I can actually do under the Chapter 11 regime in the US? What's sort of the significant difference? Because of course, that's how the Singapore regime has been set up, to be an Asian parallel to Chapter 11. But what are some of the gaps that you've seen?
Well, I think there are a few things. First of all, as I mentioned earlier, our jurisprudence isn't quite as developed as that in the US with respect to DIP financing. We haven't yet had a case on priming liens, for example, and what constitutes adequate protection to the existing secured creditor, and what constitutes relief in the form of an indubitable equivalent to the secured creditor. These are probably the most pressing questions with respect to DIP financing. Secondly, I think as well, challenges here are, for example, the cost of not necessarily to the DIP financing lenders, but to the debtor, would be the cost of rescue financing. Again, I think given the uncertainty and the novelty of the regime, it is actually much more expensive in Singapore than in the US. I mean, this is ad hoc, and I have not verified this information, but I've been told that in the US, it costs about 6 to 8%, whereas in Singapore, it ranges from 15% upwards, which is really much more expensive. I mean, Angelina, in your experience, perhaps you could hop in here and tell us what your experience is in terms of that cost. Other more general challenges in Singapore includes, the culture of shame, or as Pooja, what you said earlier, the denial mentality, and hence the reluctance to reach out earlier for help, to engage early with advisors and creditors, as Angelina said. There is also a reluctance to provide full and frank information by the sponsors. This is quite an issue, I feel, in Singapore, given that many of these companies are family owned and information is very much controlled amongst a small number of people. When this happens, this creates suspicions amongst creditors, and it really does not help to create cooperation. And in Singapore, unlike the US, there is no prescriptive obligation for such information to be provided without a court order. So this really means that creditors are put on the back foot for having to make specific applications. So these are some of the challenges I can think of. So back to you, Pooja.
Okay. Thanks, Mei. I think that's very useful. I think that's exactly the kind of practical questions that one gets asked from those who are not based in Asia but are interested in investing in Asia. So let me just pivot back to India. So I think Pooja, Mahajan, question for you, and I think this is kind of half of my earlier question. I think, what are some of the challenges you've seen in particular with international players looking to extend rescue financing in its different shapes and forms in India?
See, as far as the challenges for international players are concerned, a lot of it is common in terms of just general rescue finance.
Right.
I think outside the IBC process, one of the big issues is understanding what the priority of rescue finance is going to be. We don't have a regime where you can go to court and get an order as far as priming of or priority of rescue finance is concerned. So the challenge that a lot of financiers face is, what will happen in case the company ends up in insolvency? What is going to be the status of the finance that they have given as rescue finance? And that's the reason why they always look for a security as far as India is concerned. They look for exclusive charges, they look for exclusive security, because that's something that will hold good in case the company goes into insolvency. And Mayuri mentioned some of those challenges around creation of that security package for someone who's providing a rescue finance. We have very complex security structures in India. Different types of security. Working capital lenders have one set of security, term loan lenders have another set of security. So just finding the right security package sometimes becomes a big challenge. We have challenges where the existing lenders, a lot of them being public sector undertakings, public sector banks, who are very, very concerned about ceding charges. And as Mayuri mentioned, the entire process around the ceding of the charges and coming to some sort of a consensus amongst the public sector banks is a big challenge. And I also feel that as far as public sector banks in India is concerned, and we have to realize that a lot of lending in India has taken place by the public sector undertakings in the past. A lot of the public sector undertakings have issues around accountabilities. They are worried about investigations that may be started against them. And that's a big, big factor, which actually I feel discourages them from doing an outside IBC process of rescue finance. And a lot of them feel more comfortable if you have a court blessing or a regime under the overall supervision of a bankruptcy tribunal. So I think that's one big issue where pre-IBC rescue finance is concerned. The other, of course, from a foreign funds perspective is, as of now, they can't really do a direct buyout of non-performing loans. They have to go through the mechanism of an asset reconstruction company, which is, of course, a discouragement as far as, giving buying out debts of non-performing loans is concerned.
It's like you have to actually, Sajna says, like you have to actually manufacture the factory that's going to produce the parachute.
Absolutely, because they can't do it directly. So that's one big issue here. And I think I want to talk about one point which Angelina also touched earlier on, is engaging early on. The IBC trigger in India, the Insolvency and Bankruptcy Code trigger, is really the default. There is, there has always been a reluctance as far as Indian promoters is concerned to engage early on. We don't really have a very robust wrongful trading or insolvent trading regime. So there are no real disincentives, so to speak, in engaging early on. But I think that is slowly changing, because what IBC has brought about is a mindset, and there's a real fear that the promoters may end up losing the company. So we are very slowly seeing the engagement actually happening at the time when the stress has started showing, rather than a stage at which default has actually occurred. So that, I think, is a positive move and a positive development. So that's as far as pre-IBC is concerned. Post-IBC challenges, I mean, I already touched upon the NCLT process, the entire difficulty around the timelines in the NCLT process. The other big issue, of course, is the Section 29A. There is very little incentives as far as promoters is concerned to provide any kind of rescue financing once the company goes into IBC. Right. And even from a perspective of the lenders, you don't really see interim finance really being provided during the IBC process. And I think that again goes back to the fact that you need creditor approval for any kind of interim finance. And from a practical perspective, we see the public sector undertakings who form majority of the members of the Committee of Creditors being very uncomfortable taking any kind of calls on rescue finance or interim finance. And they are more comfortable waiting out for a resolution process to complete and getting the blessings of the NCLT rather than taking any call by themselves on interim finance. Right. I think these are some of the broad challenges that we face in India.
Yeah, I think it's the old common problem across Asia of building the consensus, and then it just kind of hits a natural roadblock if you don't have a court process to kind of impose that consensus, once there's agreement above a certain threshold. If I could just hand over to Mayuri, I think we'll just try and wrap up in the next 5 to 7 minutes. Big buzz in India around the pre-pack regime. So what's your view on that, and how is it going to change, if at all, the culture of rescue financing?
So I think both Pooja, Mahajan and Angelina had briefly touched upon it, uh, in the specific challenges that they were talking about. So just taking on from there, see the fundamental difference between rescue financing, which is still a developing concept in India, and insolvency, which is now a slightly more mature regime. The fundamental difference is that rescue financing believes in debtor in possession, whereas insolvency code in India is actually a creditor in possession regime. So that way, to that extent, this whole concept of pre-packs should be actually a shot in the arm, because it is about identifying the stress early on, and engaging with the stakeholders, including your lenders, to arrive at a mutually acceptable solution. Now, of course, the one very important thing to keep in mind is how to avoid the challenges which plague or are still not addressed completely in the insolvency regime, i.e. the protracted timeline in the name of value discovery and value maximization. That is something which will definitely need to be avoided, because time is of the essence when we speak about rescue financing. uh, I would say that this is still a work in progress, because we are yet to see how it will actually be promulgated into a formal law, and more importantly, how it's then going to be practiced. So that waits to be seen. But nonetheless, this whole concept of pre-pack regime uh, is going to be quite a boost to the whole concept of rescue financing in India.
Okay, thanks. And one final quick question, maybe. So, you guys are kind of international, but also domestic. What's your view on how the domestic versus international divide plays out in restructuring processes in India, as far as creditors are concerned? Would you say there's parity?
So actually, see, the source of funds for Ares SSG is offshore. So to that extent, it is it is international. The only thing is that there is an office in India. There are people, so the context and the ability to do the heavy lifting in terms of negotiation and resolving a solution. Arriving at a solution is what helps with the on-ground presence. In terms of the regime per se, there is actually not a difference between domestic versus onshore versus offshore investors. The only difference arises from something like the FDI policy in India, which is not specific to the insolvency code, because that has got a restriction around ownerships of businesses by offshore investors. But other than that, if there is on the ground presence, and there can be very close engagement with the different stakeholders in the process, then it is very much a level playing field. Back to you, Pooja.
Pooja,
Pooja, you are on mute, I suppose.
Yes,
Pooja,
sorry, yes.
Sorry, may I just pose a question to Mayuri, which I think is something that came up in our kind of pre-discussion around the use of pre-packs and the reason for using pre-packs in India, as distinct from, the reason that sort of post-global financial crisis, pre-packs were generally being used in the UK under the laws of England and Wales. And Mayuri, I just wondered whether you wanted to make that distinction, because of course, pre-packs in Western Europe, and in particular under England and Wales law, came under quite a lot of criticism for kind of avoiding unsecured creditors of the company and facilitating essentially owners of a business shedding all of its old liabilities and then just buying back the business kind of clean and continuing to run that business as if nothing had ever happened. So when we talked about it, you had some observations around how this is different in India and what are the drivers in India that I thought would be worth sharing.
Sure, Angelina, thank you. So this whole concept of, and this is something that Pooja Mahajan had also alluded to when she was talking about the whole IBC regime, there is this whole concept of Section 29A, which is responsible for the behavioral change that I had touched upon earlier during our conversation, because promoters now realize that they cannot, there is no backdoor entry to the asset. So this is very well laid out in IBC. While this is yet to be promulgated formally, but what we do understand is that even in case of a pre-pack, which is very relevant for rescue financing, a similar bar is going to be applied. So the effect is going to be twofold. One is that the promoters will realize that if they actually try to get away with default, the company is going to be taken away from them, and they will not be able to get back in the controlling position at all, or for that matter, any sort of ownership in the company, not just directly by themselves, but even indirectly. So 29A is, it involves a lot of scrutiny around the ultimate beneficial owner of the resolution applicant and all of that. So there is no way for the defaulting promoter to get back. And the second thing which the promoters are now going to do is this whole thing that Angelina, you've been speaking about, early engagement, because promoters will now want to avoid a default, so that they are not pushed out of the situation. So they will want to engage at least 12 to 15 months prior to the actual occurrence of default, so that they can get to a solution in which they continue to run the company with the oversight of the lenders, and it creates value for the existing lenders, the new lender, as well as for the promoters themselves. Thank you.
Got it. Thank you. That's very helpful, Mary. Okay, I think we're almost at the end. I think just one final question for Angelina. I think you probably have sort of most regional perspective of us all. You've also seen kind of pre-pack schemes of arrangement outside the Asian context as well. So what do you see sort of evolving as the most effective rescue financing tool in Southeast Asia? Or is the answer going to be, it just depends? I think that's unfortunately the answer for many things in Asia.
I think that's right, Pooja. I mean, I have big hopes, and I feel a lot of excitement when I think about the opportunities that are available under the Singapore process. And I think that as the jurisprudence develops and the Singapore courts sort of work out where they want to strike that balance between the interests of debtors and the interests of creditors, I think that becomes a really, really interesting area of focus. The developments in India, I was talking to someone about this yesterday, are really interesting in the sense that there is the real desire to want to create a process that is efficient, that people have comfort and provide certainty of outcome, and is able to resolve queries and questions in a commercial way. And there have been a number of different regimes that have been introduced in India over the last sort of 10 or so years, and each one gets incrementally better. And each one, I feel a lot of hope listening to Pooja and Mayuri talking about what the process in India is now doing in terms of influencing that borrower behavior. So I think there is a huge amount of opportunity. There are some jurisdictions that are lagging behind that, but the beauty of the way the courts are applying the Singaporean process in particular means that it is absolutely possible for Singapore to start to become the restructuring hub that it has set out to do. And I think, as I say, as that jurisprudence starts to develop, we will see more of that.
Okay, thank you. I think hope, opportunity, I think all words that we need to hear. I think, Mei Yen, since we've talked about Singapore, I'll maybe just hand over to you for any final observations. But before that, just a quick reminder, if you do have questions, please use the chat feature to feed those in, and then I'll take those up. Mei Yen, over to you.
Well, I think we were talking about pre-packs just now, and Singapore just introduced, together with DIP financing, a pre-pack procedure whereby companies can now come to court to apply for sanction of a scheme without actually going through a court-convened meeting. And I think what I found now is that this has been extremely useful. And based on my experience, one class of debtors that have been particularly interested in that is the Indonesian companies that have bonds issued out of Singapore, for example. I think they've been looking at one of the first cases I did, which was MNC, and we had worked around this and we decided let's go for pre-pack. And it was successful. It's been sanctioned by the court. We got the requisite majority in terms of the creditors, and we had absolutely no issue whatsoever. It was very smooth going. And following that, other Indonesian companies have come forth. I mean, we've got Modern Land now also using the Singapore court procedure for the same pre-pack. And we have inquiries from other Indonesian companies too. And I think one of the things that they really like about the Singapore procedure via the scheme, and in this case is the pre-pack scheme, apart from the cost and time savings, is the fact that it only focuses on the bonds that they intend to restructure. Whereas if they were to go for the alternative in Indonesia, which is the PKPU process, they would then have to put the entire body of creditors into a process, which will be highly disruptive in terms of their ongoing business and their existing lendings in Indonesia. So going forward, I actually do expect that we're going to see much more interest from our neighbors in Indonesia in restructuring their offshore debts in Singapore.
Right. Thank you. I think this is going to be one of those interesting themes that plays out, because it's going to be export of legal tools, but also import of cultural baggage, so to speak. So it'll be interesting to see how all of that plays out. Okay, so I think that's all very great.
I was going to say just one more point on that. I think what the Indonesian debtors have discovered is that by coming to Singapore, one very important factor is that the creditors are willing to engage. And I think that was quite important in terms of sort of validating themselves as being genuine about restructuring. Instead of doing it in Indonesia, having done it in Singapore, the experience has been that creditors' cooperation did exist, and that was good. Sorry to interrupt you, Pooja. That's the last point I wanted to make.
Understood. You're sort of proving good faith by showing up to the Singapore table. I think all of that has been fantastic interventions on everybody's part. We'll proceed to close. I think just taking a very quick step back, if you look at the title, I don't know if anybody's actually read the book on parachutes. It's a self-help book. I'm a bit of a self-help nerd, so I've actually read it, and it's interesting because it's picking up several themes that we've also discussed on the panel. It's about applying creativity to solve old problems in new ways. In that, the book is about sort of job searching. It's about going back to the drawing board, finding really what drives you, and then more innovative ways to find your dream job. And in a similar theme, I think rescue financing is all about customization, all about engaging early before the problem actually appears, and it's about just finding bespoke solutions that suit the particular situation. So with that, I'll bring the panel session to a close. Thanks to everybody who joined in. Big thanks to our stellar panel, particularly to our India members and friends who've dialed in at a very unearthly hour. And also thanks to the IWIRC III team for initiating this fantastic and historic series of all-women panels.
Thank you, Pooja. Thank you to all of our panelists, and thank you to everyone for participating.